Now, I normally wouldn't put my face on camera. However, with last week's landmark Supreme Court decision that makes marriage equality the supreme law of the land, I think we deserve a special dramatic reading. Not of the whole opinion, that's 103 pages. However, Justice Scalia has provided us with a quite entertaining dissent. So stick with me, it's going to be fun. It's no Hogwarts School of Prayer and Miracles, but it's a good time. So, without further ado, I present to you the Honorable Justice Scalia's dissent. The Supreme Court of the United States, James Obergefell et al. Petitioners versus Richard Hodges, Director, Ohio Department of Health. June 26, 2015. Justice Scalia, with whom Justice Thomas joins, dissenting. I join the Chief Justice's opinion in full. I write separately to call attention to this court's threat to American democracy. The substance of today's decree is not of immense personal importance to me. The law can recognize as marriage whatever sexual attachments and living arrangements it wishes, and it can afford them favorable civil consequences from tax treatments to rights of inheritance. Those civil consequences, and the public approval conferring the name of marriage evidences, can perhaps have adverse social effects, but no more adverse than the effects of many other controversial laws. So it is not of special importance to me what the law says about marriage. It is of overwhelming importance to me, however, who it is that rules me. Today's decree says that my ruler and the ruler of 320 million Americans coast to coast is the majority of 9 lawyers on the Supreme Court. The opinion in these cases is the furthest extension, in fact, and the furthest extension one can even imagine of the court's claimed power to create liberties that the Constitution and its amendments neglect to mention. This practice of constitutional revision by an unelected committee of 9, always accompanied, as it is today, by extravagant praise of liberty, robs the people of its most important liberty they asserted in the Declaration of Independence and won in the Revolution of 1776, the freedom to govern themselves. Roman numeral 1. Until the court put a stop to it, public debate over same-sex marriage displayed American democracy at its best. Individuals on both sides of the issue passionately, but respectfully, attempted to persuade their fellow citizens to accept their views. Americans considered the arguments and put the questions to a vote. The electorates of 11 states, either directly or through their representatives, chose to expand the traditional definition of marriage. Many more decided not to. Win or lose, advocates for both sides continued pressing their cases, secure in the knowledge that an electoral loss can be negated by a later electoral win. That's exactly how our system of government is supposed to work. The Constitution places some constraints on self-rule, constraints adopted by the people themselves when they ratified the Constitution and its amendments, forbidding laws impairing the obligation of contracts, denying full faith and credit to the public acts of other states, prohibiting free exercise of religion, abridging the freedom of speech, infringing the right to keep and bear arms, authorizing unreasonable search and seizures, and so forth. Aside from these limitations, those powers, reserved to the states respectively or to the people, can be exercised as the states or the people desire. These cases ask us to decide whether the 14th Amendment contains a limitation that requires the states to license and recognize marriage between two people of the same sex. Does it remove that issue from the political process? Of course not. It would be surprising to find a prescription regarding marriage in the federal Constitution since, as the author of today's opinion reminded us only 2 years ago in an opinion joined by the same justices who joined him today, and I quote, "Regulation of domestic relations is an area that has long been regarded as virtually exclusive province of the states. The federal government, through our history, has deferred to state law policy decisions with respect to domestic relations," end quote. But we need not speculate. The 14th Amendment was ratified in 1868. Every state limited to one man and one woman, limited marriage to one man and one woman, and no one doubted the constitutionality of doing so. that resolves these cases. When it comes to determining the meaning of a vague constitutional provision such as due process of the law or equal protection of the laws, it is unquestionable that the people who ratified that provision did not understand it to prohibit a practice that remained both universal and uncontroversial in the years after the ratification. We have no basis for striking it down as a practice that is expressly prohibited by the 14th Amendment's text, and that bears the endorsement of a long tradition of open, widespread, and unchallenged use dating back to the amendment's ratification. Since there is no doubt whatever that the people never decided to prohibit the limitation of marriage to opposite-sex couples, the public debate over same-sex marriage must be allowed to continue. But the court ends this debate in an opinion lacking even a thin veneer of law, buried beneath the mummeries and straining to be memorable passages of the opinion that is a candid and startling assertion. No matter what the people ratified, the 14th Amendment protects those rights that the judiciary, in its reasoned judgment, thinks the 14th Amendment ought to protect. This is because the generations that wrote and ratified the Bill of Rights and the 14th Amendment did not presume to know the extent of freedom in all of its dimensions. One would think that that sentence would continue, quote, and therefore provide a means, perhaps, in which the people could amend the Constitution. Or perhaps, quote, and therefore they left the creation of additional liberties, such as the freedom to marry someone of the same sex, to the people through the never-ending process of legislation. But no. What logically follows in the majority's judge-empowering estimation is, and so they entrusted future generations a charter protecting the rights of all persons to enjoy liberty as we learn its meaning. The we, needless to say, is the 9 of us. Quote, history does not set, quote, history and tradition guide and discipline our inquiry, but do not set its outer boundaries, end quote. Thus, rather than focusing on the people's understanding of liberty, the majority focuses on the 4 principles and tradition that, in the majority's view, prohibit states from defining marriage as an institution consisting of one man and one woman. This is a naked judicial claim to legislative and indeed super-legislative power. A claim fundamentally at odds with our system of government, except as limited by a constitutional prohibition agreed to by the people. States are free to adopt whatever laws they like, even those that offend the esteemed justice's reasoned judgment. A system of government that makes the people subordinate to a committee of 9 unelected lawyers does not deserve to be called a democracy. Judges are selected precisely for their skill as lawyers. Whether they reflect the policy views of a particular constituency is not, or should not be, relevant. Not surprisingly, then, the federal judiciary is hardly a cross-section of America. Take, for example, this court, which consists of only 9 men and women, all of them successful lawyers who studied at Harvard or Yale Law School. We'll pause to read footnote 18. The predominant attitude of tall-building lawyers with respect to the question presented in these cases is suggested by the fact that as the American Bar Association deemed in accord with the wishes of its members to file a brief in support of the petitioners. Back to the opinion. 4 of these 9 are natives of New York City. 8 of them grew up in East and West Coast states. Only 1 hails from the vast expanse in between. Not a single Southwesterner, to tell the truth, or even a genuine Westerner. California does not count. Not even a single evangelical Christian, a group that compromises about 1/4 of Americans, or even a Protestant of any denomination. This strikingly unrepresentative character of the body voting on today's social upheaval would be irrelevant if they were functioning as judges, answering the legal question whether the American people had ever ratified a constitutional provision that was understood to prescribe the traditional definition of marriage. But of course, the justices in today's majority are not voting on that basis. They say they are not. And to allow the policy question of same-sex marriage to be considered and resolved by a select patrician, highly unrepresentative panel of 9 is to violate a principle even more fundamental than no taxation without representation. No social transformation without representation. Roman numeral 2. But what really astounds is the hubris reflected in today's judicial push. The 5 justices who compose today's majority are entirely comfortable concluding every state violated the Constitution for all of the 135 years between the 14th Amendment's ratification and Massachusetts permitting the same-sex marriages in 2003. They have discovered in the 14th Amendment a fundamental right overlooked by every person alive at the time of ratification and almost everyone else in the time since. They see what lesser legal minds like Thomas Cooley, John Marshall, Harlan, Oliver Wendell Holmes Jr., Learned Hand, Louis Brandeis, William Howard Taft, Benjamin Cardozo, Hugo Black, Felix Frankfurter, Robert Jackson, and Henry Friendly could not. They are certain that the people ratified the 14th Amendment to bestow upon them the power to remove the questions from the democratic process when it is called for by their reasoned judgment. These justices know that limiting marriage to one man and one woman is contrary to reason. They know an institution as old as government itself and accepted by every nation in history until 15 years ago cannot possibly be supported by anything other than ignorance or bigotry. And they are willing to say that any citizen who does not agree with that, who adheres to what was until 15 years ago, the unanimous judgment of all generations and societies, stands against the Constitution. The opinion is couched in a style that is pretentious as its content is egotistic. It is one thing for separate concurring or dissenting opinions to contain extravagances, or even silly extravagances, of thought or expression. It is something else for the official opinion of the court to do so. Footnote 22. If, even as the price of being paid for a fifth vote, I ever join an opinion for the court that began, the Constitution promises liberty to all within its reach, a liberty that includes certain specific rights that allow persons within a lawful realm to define and express their identity, I would hide my head in a bag. The Supreme Court of the United States has descended from the disciplined legal reasoning of John Marshall and Joseph Story to the mystical aphorisms of the fortune cookie. Of course, the opinions showy profundities are often profoundly incoherent. The nature of marriage is that through its enduring bond, 2 persons together can find freedoms such as expression, intimacy, and spirituality. Really? Whoever thought that intimacy and spirituality, whatever that means, were freedoms? And if intimacy is, one would think that the freedom of intimacy is abridged rather than expanded by marriage. Ask the nearest hippie. Expression, sure enough, is a freedom, but anyone in a long-lasting marriage will attest that the happy state constricts rather than expands what one can prudently say. Rights, we are told, can rise from a better informed understanding of how constitutional imperatives define a liberty that remains urgent in our own era. Huh? How can a better informed understanding of how constitutional imperatives, whatever that means, define whatever that means, an urgent liberty, never mind, gave birth to a right? And we are told, in any particular case, either the Equal Protection or Due Process Clause may be thought to capture the essence of a right more accurate and comprehensive way than the other, even as the 2 clauses may converge in the identification and definition of a right. What say? What possible essence does substantive due process capture in an accurate and comprehensive way? It stands for nothing whatever except those freedoms and entitlements that this court really likes. And the Equal Protection Clause, as employed today, identifies nothing except a difference in treatment that this court really dislikes. Hardly a distillation of essence. If the opinion is correct that the 2 clauses converge in the identification and definition of a right, it is only because the majority's likes and dislikes are predictably compatible. I could go on. The world does not expect logic and precision in poetry or inspirational pop philosophy. It demands it in the law. The stuff contained in today's opinion has diminished this court's reputation for clear thinking and sober analysis. Hubris is sometimes defined as the overweening pride, and pride we know goeth before the fall. The judiciary is the least dangerous of all the federal branches because it has neither force nor will, but merely a judgment, and must ultimately depend upon the aid of the executive arm, and the states, even for the efficacy of its judgments. With each decision of ours that takes from the people a question properly left to them, with each decision that unabashedly is based not on law, but on the reasoned judgment of a bare majority of this court, we move one step closer to being reminded of our impotence. Thank you, Justice Scalia, for such an enlightened and fabulous opinion. Dissent. Love wins, y'all. Have a great day.